So welcome to another episode of the Yesner Law Podcast. My name is Sean Yesner, and I'm happy to have a guest with me on this episode, Christie Arkovich. Welcome, Christie.
Thank you, Sean. I'm glad you invited me because I'm trying to get the word out on student loans and what you can do, so every little bit helps.
Absolutely, and that's what I would love to talk about today is student loans. So Christie is another attorney who, very much like me, does a lot of the foreclosures and bankruptcies and short sales and loan modifications and consumer cases and consumer protection type cases. But Christie has a lot of experience with student loans, and so that's why I wanted to have her on this episode of the podcast. And so a lot of times when people think about student loans, they think about, well, can I file bankruptcy to discharge my student loan? And the answer in a lot of cases is no, you can't. But in talking to Christie, there's actually some non-bankruptcy alternatives available to either eliminate or soften the blow of a student loan, right?
Yes.
So what are some of those things? What can you do to help someone who's being overburdened by their student loan payment?
Sure. Well, most people come in to see us and they're either not making payments and they're in default, and in that case they might be facing garnishment or something like that, or they're making these huge payments, $750, $1,000 a month, and they're not making a dent. You know, loan balance is actually even going up. And so for those clients, they realize they have to do something, but they recognize that most of the publicity out there is that you cannot discharge a student loan in bankruptcy. Most of the bankruptcy attorneys will tell clients that. It's on their websites and so forth. But the fact of the matter is that there's a lot of things outside of bankruptcy we can do, and even inside we can do a few things. Unlike the traditional undue hardship cases that we'll hear about, we're not targeting those. That's very difficult to win. So outside bankruptcy.
And when you say undue hardships, for those that are not familiar, and correct me if I'm wrong, but what we're talking about is a person who files bankruptcy and says, I have these student loans, and even though they would not normally be dischargeable, I have some type of extreme undue hardship that prevents me from having the ability to pay back my student loans. And so for that reason, bankruptcy court, you should go against the normal rule that they're not dischargeable, and in my case, you should discharge them.
Yes, the undue hardship cases are difficult to meet because you have to show for the majority of the repayment period, which is nearly 25 years, that you can't repay your student loans and maintain a minimum standard of living, and that's very hard to show.
Right.
So we're not focusing on those so much. For the bankruptcy clients, there's actually a couple of niches right now. We frequently will come in contact with clients who are siblings or friends of borrowers, and they can be discharged in bankruptcy if they're willing to file. They don't fit the qualified educational definition. We also are targeting, and we filed a case a couple weeks ago in Orlando on behalf of a student who went to a Caribbean medical school. I don't know if you knew this, but there's 50 medical schools in the Caribbean.
Yeah.
And the majority of them cannot get federal funding. Only 3 or 4 are eligible. And so for those other schools, for anyone who's paid with private loans, those are potentially dischargeable in bankruptcy due to a new case, In re Decina, that came out in the spring. That particular case was actually reversed because they didn't properly serve the bank, but it's been cited favorably by 2 other cases, and it's really the beginning of something new, I think.
Is that a Tampa case?
No, these are outside of Florida.
Okay.
So we're hoping to bring a Florida precedent in our Orlando case.
Okay.
And then we've got one in West Palm that we're about ready to bring that's on behalf of a friend who signed for a now deceased friend who was the borrower.
Wow.
And so we think the rules also would permit him to be his loans to be discharged. So we do have a few specialized cases in bankruptcy, but ordinarily we're not filing a lot of undue hardship cases because that standard is very tough to meet. It itself is on appeal in the 11th Circuit, but we have to wait probably another year to hear on that. So really what we're focused on is the outside of bankruptcy things.
So what are some things you can do outside of bankruptcy?
Well, if we're talking about federal loans, for instance, there's something brand new. Everybody's heard about ITT closing. You know, it closed
Right.
down in September. It's in the news everywhere. Well, as a result, or not necessarily as a result of that, but as a result of Corinthian last year, the Department of Education has created a new program called Defense to Repayment. And basically what you have to do is you have to show that some kind of fraud occurred, that this student was either the victim of some kind of misrepresentation on job placement rates, job guarantees, salary ranges. Accreditation is another one. They think that the credits will transfer. They're led to believe that the national accreditation of a for-profit school is actually better than regional, which it's clearly not. There's differences in accreditation. A lot of students don't realize that. So anyway, so they have some kind of misrepresentation. They rely on that. They take out the federal loans. If they can show that they discovered that this was a lie, that this was untruthful within the last 4 years, we can go back potentially 12 years to perhaps discharge their federal student loans. And so that's a new program, just came out on November 1.
And you mean student loans that were taken out 12 years ago?
Yes.
Okay.
Yes. As long as we can use the discovery rule in the state of Florida under fraud cases to go back and say that our client learned of it within 4 years, they can now go back up to 12 years for student loans that are dated that long. But we have to have something discovered within 4 years. And so basically we're starting to file those applications. That's on behalf of students for ITT. IADT is another popular one here in Tampa, International Academy of Design and Technology. There's a lot of those. And before, they really didn't have this remedy. There was an IADT class action filed by another attorney locally a couple years ago, and it was dismissed by the Middle District of Florida, their class action, because they were ordered to arbitration. One of the unfortunate things is many of these enrollment agreements that the students sign unknowingly have arbitration clauses. And so class actions don't really go anywhere. And now in ITT's case, they're in bankruptcy. So I'm not sure who would want to sue them. Interestingly, though, yesterday there was a bunch of documents filed in an adversary proceeding brought by ITT students. There's a nonprofit group that is handled by some Harvard attorneys. And they filed yesterday an adversary proceeding with a bunch of ITT documents and things. So maybe they'll get an adjudication. And if they do, of fraud, then that can be used in any of these DTR applications.
Wow.
So that's pretty big right now.
What else is out there? What else?
DeVry, they were just cited and settled for improperly stating a 90% job placement rates. So we'll start to see those applications come in. ACICS was shut down in November. That's the accreditor for these for-profit schools.
Oh, wow.
And and it lost its federal accreditation. So that's huge because now all these schools have 18 months to go find another accreditor, and many of them are probably going to close when they don't meet the qualifications required. So we'll have a lot more.
Is there a difference between the school advertising, puffing, versus they really didn't have? I mean, if they say our job placement rate is 90% and it ends up being 88%, or are they saying you said the job placement was 90% and it's really 12%?
Well, it depends on how specific they are. In DeVry's case, that the FTC brought in action, they had on their website 90% job placement. But the problem is that they included things that they shouldn't have included in those calculations. They counted people that already had the same job as being employed after the DeVry education.
Oh, people that had a job went to DeVry and kept
went
their
back
job.
to the same job.
Okay.
Yeah, they counted people as waiters when they weren't utilizing the education, and so how they stated the job placement rate, they would say it was in their field of study, and so they were specific. So the more specific the representation, the more likely there's fraud. If it's broad, you're going to get a job. Well, that's puffery.
Right.
That's something that isn't not really actionable.
Right. Okay.
So anyway, so these applications are one thing. With federal loans, there's also a lot of great income-based payment plans that have debt forgiveness with the federal government. Those are excellent. The problem there is people sometimes will pick the wrong one, so sometimes some advice is to get into the correct program is helpful. But that basically is intended to lower the payments because our whole goal with these student loans is to try to get folks into a affordable and sustainable payment with an end in sight, because that's not what we're seeing now. Before a client comes to us, they usually have a payment that's outrageous and they can't possibly make it. It's equal to their mortgage payment. So in our goals are trying to get a mortgage payment down to something that might be more car level, or a car payment something down to maybe a utility bill level.
Right.
And it's working. We're not trying to get rid of loans entirely. We're trying to get them reduced. And so the income-based programs are excellent for that. We can usually help 9 out of 10 folks that come and see us. Every once in a while, there's someone that we can't do anything for, of course. And then you've got those private loans. And the private loans are entirely different. There's no income-based programs. But for those, we might have a statute of limitations. We might have some consumer law violations. One of our favorite tools that we like to use right now is we tell our clients, revoke consent to call your cell phone.
Right.
Verbally talk to the servicer, tell them not to call, keep track of calls, write down when you told them. And potentially the violation is $500 to $1,500 per call, and that creates some great settlement leverage to get those loans down. Because our goal in private loans is, unlike federal, they do settle. And we often can get between 10 and 50 cents on the dollar. maybe not all at once either. Some are lump sum, but other ones might have a little bit of a down payment and payments that go out 2, 3, 5, 10 years.
Right.
But we're trying to get away from the 20, 25-year forever type plans and get it much more reasonable. And most of this all helps people rebuild their credit so they can buy houses in a couple of years and so forth. So there's things we can do.
Yeah, and with a lot of these options, they're also avoiding bankruptcy. In
Yes.
a lot of cases, which I know a lot. The first thing whenever I get a call about a student loan issue, it's, do I have to file bankruptcy? And the irony there is, well, even if you do file bankruptcy, like we talked about, it may be really hard or impossible to discharge that student loan anyway. So it's interesting that they're getting the results that they wanted without the drawbacks that they were afraid of, and they're still able to settle the debts. They're still able to get, like you said, their student loan payments down to something that's affordable.
Mm-hmm. And we can also cure defaults. Like you've got a client in a federal loan that is facing wage garnishment or tax intercepts or maybe even Social Security offsets. For those clients, we can do rehabs, consolidations, bring them current, help their credit out, and we don't need bankruptcy for that either. The only time we really use a bankruptcy is if we can't rehab, we can't consolidate for different reasons, then we're forced into a bankruptcy to stop the garnishment. I don't think I've actually seen that. I've always been able to rehab or consolidate
Good.
for a client.
Cool. Is there anything else that you wanted to talk about or mention?
Just to reach out, try to get information. Don't assume you can't do anything, because most of the clients who come and see me, I didn't think I could do anything, but I thought I'd just check.
Well, and not to speak for you, but I do free consultations. I assume
I do too.
So even to reach out to you, to reach out to me, to reach out to some attorney, I think most of the attorneys in the Tampa Bay region anyway, in terms of these types of issues, will do a free consultation. And I think we're all pretty good about bending each other's ear and referring cases to each other and all that other kind of stuff too. So I think the message is, get to one of us and we'll get you to the right place to get the resolution you need.
And our free consultation can be done on the phone. A lot of people don't have time to come in.
Right.
It's a long drive. We work out of county too, so we do phone consults pretty much every day. Tuesday through Thursday is best days to reach us. And the things are working, so I don't want people just to assume that there's nothing that they can do.
Right. And so if someone does want to reach you, how do they do that? What's the best way?
Well, our phone number is 813-258-2808. But we love email. Got a website under my name, Christie, Christie, Arkovich, ARKO, as in Victor, ICH.com. We've got a blog. You can link to it on our website, but it's Tampa Bankruptcy Lawyer blog.com. I never say that, so it doesn't run off my tongue very well. On that, we've got a section on student loans with quite a lot of information on there.
Okay.
And we have a Student Loan Survival Center on our website that has a lot of information too. We're very informational on our website because the student loan program is the least transparent area of law I've ever seen.
Yeah.
And we try to help with that transparency problem to let people know why we're doing what we're doing, what can be done, and make it just more visible.
Very nice. And for the listeners, I will post all those links in the notes, so you'll see all those. If you didn't catch when Christie was given the phone number, the website, the blog site, I'll post all of that, as well as my contact information, which is Sean@yesnerlaw.com, or the website. And also I've got my social media pages, Facebook, Google, all that kind of stuff. So, Christie, I appreciate you being on the episode. And I appreciate all the information, and thank you for being here. And like I say at the end of every episode, if you have questions that you think would make a great topic for a future podcast, please reach out to me. Let me know. We'll make sure we address that topic in a future episode. I thank you for your time and listening. Thank you again, Christie, for being a guest on the show, and I will talk to you on the next episode of the Yesner Law Podcast.
Thank you, Sean.
Thanks.